pardon to mention, my lord, item number 286 of the weekly list. Your lordship has directed to deposit the entire amount because he has given a first certificate for which your lordship wants to know the certificate to be produced on that day. It is 286. It will be infructuous because no interim order was there. I have already deposited the amount. The lordship may consider last case. It's anticipatory bill. It is your lordship has directed to
286.
Yes, madam.
ଶୁଣୁନ କି କଣ ସେ କହୁଛନ୍ତି ସବମିଶନ କରୁଛନ୍ତି। So
I have already deposited, my lord. I have got the receipt, everything.
all right, yes, Mr. Tripathi.
Yes.
It's an anticipatory bail application. So he produced fake certificate and got employment. And
16 months salary of rupees 1 lakh.
what is that employment nature of?
Contractual teacher, my lord. 16 months he has drawn salary of
in which school?
So that is at Balangir, my lord. And one of the co-accused has been released. Thereafter, I have requested I will deposit the entire amount. The lordship has considered and directed.
No. Which school you were there?
That is there in serial number 4 of that appointment disengagement letter.
What is that letter?
That is after FIR it was there, madam.
Chandrasekhar Meher.
Yes, madam.
Chandrasekhar Meher is block Khapra Kol and school name is Pulki Munda. Okay.
Yes.
So there was a direction to deposit that amount which whatever he has received from salary, and you have taken instruction and told on the other day that the amount total salary he has received is 1,39,816. Therefore, there was a direction to deposit that amount in the court of SDGM Patnagarh. Now he says that he has deposited the amount. Where is the document?
Document I have already put a memo. I will file, madam.
Why is you mentioning?
Immediately I am within a
File. We can take up this matter.
Yes.
Item 293, my lord. I have filed.
Item 342, my lord. It is juvenile justice bail matter, my lord. My lord, co-accused bail order, my lord, disposed of by my lord Justice G. Satpathy. It was a regular bail matter, but this is a juvenile bail matter.
342.
My lord.
Yes. So there was a direction to produce the case diary, and so it's not a BLAPL.
No.
The revision has been assigned to me.
Yes.
So yes.
Serial number weekly
Your Lordship,
82.
may please that may be kindly taken up supplementary any.
Okay, we'll see that. Yes.
Weekly 282 item. The disposal matter I have filed a miscase seeking for extension of time. 282.
Well, item number 297.
Please wait. Please have your patience.
Hello.
282. Where is that order? No, order sheet. So the bail application was disposed of on 15/2/2022,
My lord.
and you are directed to surrender in the court below and move an application for bail, that too within 4 weeks.
My lord.
So what has happened? Have you?
In fact, he could not able to surrender. He is a laborer, and most of the time used to go outside the state, for which time he could not able to surrender. That is why seeking for extension of time. Only 2 weeks.
Which is this item?
Item 282, my lord.
Right. Mr. Tripathi,
Yes.
I'm granting him 2 weeks IA number 1468 of 23. This is an application for extension of time to surrender in the court below to comply the order dated 15/2/2022. After going through the averments taken in the interim application and hearing the learned counsel for both the parties, 2 weeks further time is granted to the petitioner to surrender in the court below. The rest part of the order remains unaltered. IA is disposed of. Urgent
Absolutely.
certified copy be granted.
My lord, may I be permitted to draw your lordship's indulgence, my lord? Item 15 in the weekly list.
Hmm.
My lord, we have been waiting for 5 weeks. My lord, that matter, the accused who is in a rather in a not in a better footing is has been granted bail, and he is in 8 months already in the jail custody.
Now, after this supplementary is over, we'll take up this matter.
Man, hope is not there. That is why, my lord, I am mentioning.
Yes, yes, we'll see that. Yes.
And item 295, my lord. Kindly taken up today or next week in supplementary.
295. What is this matter?
Juvenile matter, he is languishing in custody more than 2 years, my lord.
295.
May I pardon to mention, my lord?
What happened then? Whether that victim has been examined?
Yes.
You have got the deposition copy.
Yes.
So pass on to the learned counsel for the state. It will come next week. Okay.
In supplementary list.
Okay.
ପାଞ୍ଚ ସପ୍ତାହ ହେଲା ଗଲାଣି
The learned counsel for the, this is item number, କେତେ number କହୁଛନ୍ତି?
295.
Learned counsel for the petitioner submits that the victim has already been examined in the meantime, and you file the certified copy of the name, and you files the certified,
Today I will file.
and you will file the certified copy of the deposition of the victim during course of the day, giving copy to the learned counsel for the state. Put up this matter on, that is next week, that is on Friday, 25th, 25th of August 2023. That is 285, na? 295. Mr. Tripathi, so you get the statement of the victim that was adjourned for the awaiting that examination of the victim. It's a case of rape, so it is adjourned to next week, next Friday.
Item 293, my lord.
Hmm.
In this case, I have filed the withdrawal memo, my lord. Can you
Disposed of as withdrawn.
And
Mr. Maharana is present. Maharana has come, Mr. Vigilance Council. Anybody is present? So ask him. I'm mentioning his name. If he's not there today, then I will write somebody else's name. Just get confirmation and tell. If Maharana has come to the court, it's all right. Or somebody else, I'll mention the name. Okay. This item is item number
293.
293, disposed of as withdrawn. Okay.
And another matter,
He
my
has
lord,
filed a memo. Yes.
already filed, my lord.
Okay.
Another matter, my lord, supplementary item number 27, my lord.
Yeah.
I have filed a documents, my lord. In the given 1 week time, my lord. Additional document I have filed 1 week time, my lord.
What is it's a CRLMP.
Yes, ma'am.
So what order has been passed? He has not served the copy of the CRLMP on the Learned Council for the Vigilance Department, and you will serve the same by Monday. So that was the order.
Given 1 week time, my lord.
Learned Council for the petitioner. This is CRLMP 1165 of 23.
Yes, ma'am.
1 more week time to serve the copy of the CRLMP petition on the Learned Council for the Vigilance Department. Place this matter in the on week commencing 28th of August 2023. In the meantime, the copy of the CRLMP is served on the Learned Council for the Vigilance Department. Yes.
Pardon to mention, my lord, fresh criminal appeal matter, my lord.
Give it.
Yeah. I will pardon. Item 246 of the weekly list, my lord.
246.
Aye. There, my lord, I filed a memo for withdrawal, my lord. There, the present petitioner. The petitioner has filed two applications. In one case, my lord, has granted bail. In the other case, my lord, it was taken up about a week after, my lord. But for wherein I have said that a report was also called for.
246.
Just prior to that, my lord, has granted bail. Sahadev Jana. That is.
So you want to withdraw
My
this
lord,
application? Why don't you file a memo?
Memo I filed.
Learned Mr. Manas Kumar Chand, Learned Council, appearing for the petitioner, files a memo withdrawal, which is taken on record. PLAPL is disposed of as withdrawn.
Okay.
Pardon, my lord, my Lawrence Indian, Mr. Mahathir.
Which item?
293, my lord.
293. What you want?
That is the I have
withdraw.
filed a withdrawal.
He wants to withdraw that up. I am recorded your name, your presence. I have noted down.
Okay.
Yes.
Item number 297, my lord.
Yeah.
My lord, this case, my lord, this is a formal amendment application is filed, my lord, as your lordship on the last occasion, your lordship was hearing the matter, and your lordship found that another annexure was to be challenged, my lord. So I have, my lord, filed the application.
97.
That annexure.
Just a minute. Last order. Okay, you took time to file an interim application for amendment of the prayer portion and also to take some grounds in the body of the petition in view of the subsequent order. You have filed that IA.
I have filed an IA, my lord, for amendment of the prayer portion.
So copy has been served on the Learned Council for the state.
Yes, sir. I have served the copy.
All right, Mr. Tripathi.
Yes, ma'am.
Is an formal amendment. I am allowing the amendment. IA numbers one. So bring that IA number 114. This interim application has been filed for amendment of the CRLMP application as per schedule. Copy of the application has been served on the Learned Council for the state. There was no serious objection to the prayer made. Accordingly, the prayer is allowed. The schedule of amendment now shall form the part of the CRLMP petition. The Learned Council for the petitioner shall file a consolidated CRLMP application. How much time you want?
In course of the day, I will file. I have already prepared, my lord. It will be filed in.
I'm giving you by Monday you file. By 21st of August 2023, giving copy to the Learned Council for the state. Okay. Yeah. IA is
Pardon to me.
Next week, list of
list this matter in the week commencing from 28th August 2023.
Pardon to mention, my lord, item 272.
Yes.
I file a IA for interim bail, and last occasion, your lordship directed to obtain instruction on the ground of my father's illness.
Okay. We'll see that.
I got तारीख आसबार थिला तो
Is
आसले
that
आज
file ready, Mr. Tripathi?
Yes,
Is mentioning the father's element is there. You are asked to obtain instruction to see whether that instruction has come or not. Bring that file. Okay. Yes.
Pardon to mention, your lordship.
my lord.
Item number 263, your lordship.
200.
Item number 263. As per your lordship last order, may you please have the 4th August 2023 regarding the element of the wife of the petitioner, your lordship.
263.
Please, your lordship.
200. What is the last order? 48. Submit that he has produced the written instructions received from so and so regarding element of the on perusal of the first title of the bail application. It is mentioned that matter out of which arises never before present. However, the registry has placed details of the earlier cases filed by the petitioner, which indicate that the petitioner earlier approved this court thrice. Subject in non-counsel submit that will file an interim application. So you are supposed to file an interim application for correction of the cause title.
Yes, I was already complied all the direction, your lordship.
Which is that item he is mentioning? 263. I refer from.
And the IN number is, your lordship, 1068 2023.
Okay. IN number 1068 of 2023. This is an application for correction of the cause title. After going through the interim application, hearing the Learned Counsel for the respective parties, prayer made in this interim application is allowed. The Learned Counsel for the petitioner shall file a consolidated petition incorporating the earlier bail application numbers, details of the bail applications of the petitioner filed before this court. How much time you want? You are required to file a consolidated BLAPL petition.
Lordship, as for your direction, no problem.
No problem. You have to file it. Your prayer has been allowed. So in that cause title, you have to mention that the matter arises out of so and so was before this court in such and such matter. You have mentioned that it was never before this court, which was not correct in view of the registry's report. Now you have sought for amendment. I've allowed your prayer. So you have to file a consolidated petition. When you will file? How much time you require?
Next week, your lordship, before next week.
1 week time is granted to the Learned Counsel for the petitioner to do the same. Yes. Matter commencing from 28th August 2023. Yes.
I am sorry to interrupt, my lord. Item 272. What happened in this case? In 1 month back, the police station jurisdiction has been changed, my lord. Item 272, my lord.
Yes.
1 month back, the jurisdiction of the police station is changed. The London State Council asked the instruction from the Chandrasekhar PS. But now,
which item you are mentioning? Which item you are mentioning?
272, my lord. Item 272.
It has been tick marked. Somebody has mentioned. Or what?
Yes, I am mentioning, my lord. What happened in this case? Last occasion, Lordship directed to obtain instruction from the Chandrasekhar PS. But
Why
in the
are you
meanwhile,
mentioning repeatedly? I have asked the State Council to bring the file. Yes.
Thana change.
I may be excused, my lord.
Yeah.
Now the receipt I have filed, I'm sorry, copy to my,
Which one?
that are 286, my lord. That anticipatory bill, only to receipt to file.
286. Pass on that. You have received that.
Yes.
This bail application of the petitioner was earlier rejected.
No, my lord. Withdrawn.
In BLAPL number CRLMC. What is that earlier application?
PLPL number 12624 by 2021.
Where is that order?
That is I have mentioned in the first item.
Yes. What is that application?
BLAPL number 12674.
12674
by 2021.
ଏମିତି କିଛି ନାହିଁ 12674 ର ସେମିତି କିଛି ଅର୍ଡର ନାହିଁ ହଁ ସେଇଟା ଅଛି ଯୋଉଟା ଚନ୍ଦ୍ରଶେଖର ମେହର have you got that copy of that order with you ଏଟା ବାହାର କଲେ କଣ ହେଇଛି find out that are you sitting there BLAPL 12674 2021 the order has not been uploaded are you sure that it was disposed of as withdrawn
Withdrawn, yes, ma'am. That is a file.
Or the Land Council for the petition, Land Council for the state. Land Council for the petitioner submitted that the earlier bail application, anticipatory bail application of the petitioner in ABLAPL number 12674 of 2021 was disposed of as withdrawn. What is the date? 29/10/2021. In the meantime, some of the co-accused persons have been granted anticipatory bail.
Yes, ma'am. The lordship was granted Gitanjali Meher. Copy is
He files the copy of the bail order, which is taken on record. When the matter was taken off on 4/8/2023, as for order dated 28/7/2023, the Land Council for the state produced the written instruction dated 3/8/2023 received from Block Education Officer Khaprakol that during the period of his engagement, by producing fake certificate, the petitioner received gross salary of rupees 1,39,000 860. Stop. Since the London Council for the petitioner submitted that the petitioner is ready and willing to deposit such amount in the court below, direction was given to the petitioner to deposit such amount in the court of London SDGM Patnagar in GR case number 701 of 2021 and to produce the documentary proof in that respect. Today, the Land Council for the petitioner has produced the order dated 9/8/2023 of the Land and SDGM Patnagar with a memo indicating that there has been deposit of rupees 1,39,860 as per the order of this court. The same is taken on record. Copy of the order has been furnished. You have received to the Land Council for the state. Considering the submission made by the Land Council for the respective parties, since the offences are travelled by magistrate, who accused has been released on bail and the petitioner has deposited the amount in question, I am inclined to release him on anticipatory bail allowed. Yes.
Supplementary list, item number 1.
Mr. Das, your associate filed a bail order.
Yes, yes.
I think a day before that,
Yes, yes, because that order.
one of the co-accused has been released on
Yes,
bail.
yes.
So, since it was produced after the order was reserved,
Yes.
so I thought it to bring it on the to be mentioned so that the other council should
Yes.
also be aware about the same.
Yes, yes.
Mr. Tripathi, have you received that copy of the bail order of the Honorable Supreme Court?
Just now.
Okay. Any other counsel for the informant is present? Mr. Chaudhary is not there.
We'll give it to him.
So, Mr. Tripathi,
Yes.
I'm bringing this matter on 22nd.
Yes.
Mr. Das says that in the meantime, this accused and another accused has also been released on bail. So,
Yes, sir.
will you just verify it? Who will take out Monday, Tuesday in the supplemental? Are you available on that day?
Even if I'm not available, I'll appear.
Okay. The Mr. Yashovan Das, Land Senior Advocate for the petitioner, is present. He has filed the bail order of co-accused. Co-accused of the
Lalit Kumar Soni.
Mr.
Satyam Pradhan.
नहीं एबे जोटा देइथिले Lalit Kumar Soni, passed by the Honorable Supreme Court. Copy of the same is handed over to the Land and Council for the state in court today, who seeks some time to verify the same. Release this matter on 22nd August 2023. Okay.
Well, for item number 1, I'm appealing for informant.
Give another copy to him. So just go through it. Okay.
Yes, yes,
Land Council for the informant also handed over the copy.
And prior to that, my lord, we had also given.
That's all right. But this document you had not given because it was passed subsequently.
Yes,
So let him go through it.
Yes,
Just
yes.
it will come on 22nd.
The problem was it's been incarnation for almost 2 years.
No, it's all right. We'll dispose of on that day. Yes.
Deep obliged.
Obliged.
Item number 2.
Seeking an adjournment, harnessing the two local security.
Yeah.
Adjournment.
Adjournment.
Harnessing two local security last of the order to my. That's right.
No, your lordship, it's on IA was withdrawn and with the direction to file fresh IA.
That is order in 21/7.
Fresh IA has been filed.
Where is the file?
No, IA was for a different purpose.
Yes, sir.
That is not there. But so far as main bail application is concerned, he wants to give you the names, address, and documents of two local sureties.
My lord.
That he has not given and is seeking for time.
Yes.
How much time you want?
1 week.
Okay, the learned counsel for the petitioner seeks 1 week for the time to furnish the names, addresses, and documents of two local sureties who are interested to take the petitioner on bail to the land council for the state. If the same is furnished, land council for the state shall obtain instructions regarding authenticity of the documents, also the genuineness of the sureties and their willingness to take the petitioner on bail. List this matter in the week commencing. So let us say that he furnishes you by next Friday. So you take another week.
Yes, yes.
It will come in the week commencing from 4th September. Okay. Date of order number 4 is inadvertently typed as so instead of so. Okay. Yun, Nali pen Lekhi debe correction. खाली दुईटाको मु काटी देकिन 3 करदुछु ना आज हला 18 तो 18/8/2023 Union.
Item number 3. Item number 4.
Please, your lordship. Lord, the petitioner has filed one interim bail petition, my lord. My lord, on the grounds that his mother is seriously ill and for thyroid cancer, an operation will be made, my lord. I have filed all the documents.
Yes, Mr. Mishra.
Call for the report, man. Take instruction, man.
My lord,
There was a direction that the Superintendent of Police Malkangiri shall make necessary communication with the Superintendent of Police of Durg district in the state of Chhattisgarh and report to this court by next date. So that order was passed on 4/8/2023. And the copy of that order was also handed over to you.
Yes, sir.
So what is the further progress? What action you have taken?
No instruction has come.
No, whether that intimation has been sent.
Yes, sir. Intimation has been sent.
So what he has done, he has not reported to you.
Not reported, my lord.
Ask the SP.
By next week, my lord, it will be.
Ask the SP to appear then.
By next week, my lord, I will.
3 ଥର ଆଜ୍ଞା ମଝିରେ ବି ଗୋଟେ ଡେଟ୍ ବି ହେଇଥିଲା ତା ଦେହରେ କହିଲେ ଫାଇଲ ମିସ୍ ହେଇଯାଇଛି ବର୍ତ୍ତମାନ ଲୋକଟା କ୍ୟାନ୍ସର ପେସେଣ୍ଟ ଅପରେସନ ସେ ହେଇପାରୁନି
Or shall I write that you are unable
My lord, I will verify in the office, my lord. Maybe this
to put
submitted
up this matter on 25th of August 2023. This is IN number 762 of 2023. On the prayer of the Land and Council for the state to obtain instruction as per the order dated 4/8/2023. It is made clear that no further instruction shall be No further time shall be granted to the petitioner. Okay, suppose it comes that your mother is really ill and your presence is necessary, but you are a man from Chhattisgarh, so you are to provide your local sureties. So you provide it so that that will also be verified.
My lord,
Are you ready with those documents?
I will inform him so that.
Let the learned counsel for the petitioner furnish the names, address, and documents of two local sureties who are interested to take the petitioner on bail. By how much time you require?
On 25th,
25th, if you will give, then he will take 1 week time at least.
before that, I will try.
Submit that he will furnish it by before 25th of August 2023. All right. So let it come on 25th. First, that part is over. Okay.
Number 5.
So that 19 would be 10. So I am scoring out 0 and making it 9. And putting my signatures. That is on, today is 18th. 18/8/2023.
Number 6.
May the Lordship confer a report from the learned court below. Even though that has been called and that called for by your Lordship, and that is there, what time has been lost for that region again? What has been? And the present petitioner who is inside the custody since 4/9/2020, he has been granted interim bail also by
No, another report was called for.
Out of 16 charged witnesses, my lord, 14 have been examined by that time.
No, that time. But now the report has come that prosecution case is closed. Statement of the accused statement has been recorded. Defense evidence is closed. Case is posted to 21/8/2023 for argument. Are the learned counsel for the petitioner, learned counsel for the state. Peruse the report dated 14/8/2023 of the Learned Trial Court, which indicates that the prosecution case is closed, accused statement has been recorded, defense evidence is closed, the case is posted to 21/8/2023 for argument. In view of the stage of trial, I'm not inclined to release the petitioner on bail disposed of. Yes, next.
Number 7.
May I please, Lordship. On the last occasion, my lord has directed to take instruction on the
Yes, my
police.
lord. Instruction has come. Instruction has come in the pen drive, my lord. This is, I'll not whisper the name of the present petitioner. The dying declaration which was recorded in the Vivo mobile, my lord, that was inserted in a pen drive, and your lordship directed to take instruction whether in the pen drive he has whispered the name of the present petitioner or not.
Petitioner name is Goni alias
Yes, yes,
Ganeshwar Pradhan.
Yes, ma'am.
So the case is based on dying declaration stated to have been made by the deceased Bhagwan Swain before PW4, which was recorded by PW4 in his Vivo mobile. And from the said mobile phone, it has been downloaded and has been stored in a pen drive, copy of which has been furnished to the petitioner. And the said pen drive has been marked as MO2 during trial. Learned counsel further submits that even though PW4 has made a statement during trial that in the dying declaration, the deceased Bhagwan Swai implicated the petitioner Goni alias Ganeshwar Pradhan as one of the assailants of the deceased persons, but after playing the pen drive, it was found that the deceased Bhagwan Swai has not uttered the name of the petitioner to be the assailant of the deceased. Therefore, the evidence as has been adduced by PW4 in the trial court during trial against the petitioner is not correct. Learned counsel for the state and learned counsel for the informant want to obtain instruction as to whether the name of the petitioner finds place in the dying declaration made by PW4, which was recorded and stored in the pen drive marked as MO2. An affidavit to that effect shall be filed by the IIC Banki police station after carefully viewing and listening to the pen drive marked as MO2, and the copy of the affidavit shall be furnished to the learned counsel for the petitioner. देखिए कौन है last? With reference to the subject of our sworn, I have the honor to say that after playing the pen drive in which the entire incident was captured from Vivo mobile phone, it was ascertained that the name of the petitioner was not stated by the deceased Bhagwan Swami, but on perusal of the case record, it was found that the statement of the witnesses so and so have been recorded under section 160, and both the witnesses stated the name of so and so as accused with others statements recorded under section so and so. Yes, who is you are the informant. So your witness is telling falsehood that in the dying declaration, the name of the petitioner finds place. It is he who has recorded that dying declaration in the mobile. Now it has been played and found that his name is not there. Are the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submitted that the petitioner and the informant the petitioner is in judicial custody since Kebedu.
My lord, 11/8/2022.
11/8/2022. And in the meantime, trial has commenced and number of witnesses have been examined. There are no eyewitnesses to the occurrence, and the case is based on the dying declaration of the deceased Bhagwan Swami, stated to have been made before PW4, which was recorded by PW4 in his Vivo mobile phone. From the Vivo mobile phone, it was downloaded and has been stored in the pen drive, and copy of the same was furnished to the petitioner, and the said pen drive has been marked as MO2 during trial. Though PW4 made a statement during trial that in the dying declaration, the deceased Bhagwan Swami implicated the petitioner, Goni alias Ganeshwar Pradhan, as one of the assailants of the deceased persons. But after playing the pen drive, it was found that the deceased Bhagwan Swami had not uttered the name of the petitioner to be the assailant of the deceased. On such submission, the land counsel for the state as well as land counsel for the informant were asked to obtain instruction as to whether the name of the petitioner finds place in the dying declaration made before PW4, which was recorded and stored in the pen drive marked as MO2. The inspector in charge of Banki police station was also directed to carefully view and listen the pen drive marked as MO2. and to submit the report. Today, the Land Council for the state has produced the report of the IIC Banki Police Station dated 15/8/2023, wherein it is mentioned that that after playing the pen drive in which the entire incident was captured from a Vivo mobile phone, it was ascertained that the name of the petitioner, Gani alias Ganeshwar Pradhan, son of Brahmarbar Pradhan of village Nuaga, Khajuriapada, T.S. Vaideswar, district Cuttack, was not stated by Bhagwan Swami. However, from the case record, it was found that the statements of witnesses Pramod Behra and Prakash Naik have been recorded under section 164 CRPC, and they have stated the name of the petitioner as accused along with others. Considering the submission made by the Land Council for the respective parties, the fact that in the recorded dying declaration, the name of the petitioner doesn't find place, taking into account the progress of trial and period of detention of the petitioner in judicial custody. Agur reject hitla.
No, my lord.
I am inclined to release the petitioner on bail allowed.
Obligement.
Shall appear before the London trial court on each date when the case would be posted for trial. Shall not try to come in contact with any of the prosecution witnesses or tamper with the evidence. Shall not indulge in criminal activities. Violation of any terms and conditions shall entail cancellation of bail. Yes.
Obligement.
It are okay.
Item number 8.
May I please? The last occasion, my lord, directed the State Council to obtain the case diary and along with the
Direction was given, my lord, to ensure the attendance of the informant for his evidence before the court, my lord. And in the meantime, the informant Prananath Das, my lord, he has been examined as PW7, my lord.
Yes.
PW7, my lord, and he has supported the case of prosecution.
Where is that evidence? PW7.
PW7, my lord. I am the informant of this case. Justice Udainath Das is my younger brother. I know the accused Babuli Sahu, the present petitioner, my lord. Produced through VC. The occurrence took place on 5/10/2010 in between 10 a.m. to 10:30 a.m. near Tabakula Chaka and of Kamara Sahi village. I, along with my younger brother, the deceased, were proceeding in one red color Bajaj motorcycle to our sister's house. My younger brother was riding the said motorcycle while I was pillion rider. The spot is at a distance of 3 kilometers from our house. We were able to take right turns from which motorcycle was very slow. The accused Babuli Sai was standing with the cycle, my lord. The examination slip is deferred, but then again on 15/7/2023, examination will continue. I know the accused standing in the dock, he is Babuli Sahu. He obstructed us by putting his bicycle in front of our motorcycle. However, we managed to control the bike from falling. My younger brother and accused Babuli Sahu had altercation, Bachcha bracket. First, Babuli Sahu abused my younger brother in Odia language, whose English version is so and so. My younger brother also used the said word against accused Babuli. Then Babuli took one knife from his backside. The whole metallic part was a palm length and stabbed the lower abdomen of my younger brother. Two persons, namely Yudhishthira Mulia and Pramesh Chandra Behera, arrived at the spot. Accused Babuli also attacked me, for which I stepped aside. Registrar shouted, for which the accused Babuli fled away towards the southern side. There was heavy bleeding from the injury of my younger brother. We tied the injury with one napkin, bracketed gamcha. It was drizzling rain. My younger brother drove the vehicle. I sat behind him, and we returned to our home. On that day near Budiasai, at the deceased suffered from head healing, so he stopped the motorcycle and took rest on the culvert. Some people gathered there, and my brother Vishwanath Das and his son Vishwaranjan Das is there. The deceased was shifted to medical in the car of one Santosh Behera. One Surendra Bhui accompanied us. On the way to medical, inside the car, my brother was crying and shouting that the Babuli Sahu killed him. Babuli bracketed, Babuli Maridala. We arrived at SC Medical College and Hospital. Kotak doctor declared my younger brother as brought dead.
Yeah, what is your submission?
Well, though the only single injury is also there, and after the disease also drive his bike along with the informant.
No, you obstructed. You then dealt a knife blow on the abdomen of the deceased, and he died while he was being taken to the SCB Medical College Hospital. The doctor declared him dead.
But though Pidol 1, he has stated that.
And you are in custody since when?
2019, 25/6/2019, my lord.
25/6.
My lord.
But the occurrence took place in 2010, so you are an absconder for 9 years.
My lord. And in this case, my lord, also Pidol 1 and Para 2, that on being asked, he disclosed on Pidol 1 as stated, on 5/10/2010 at about 10 a.m. while I was proceeding to Bhagalpur, I heard a shout, Morigali of the deceased Udayanath Sahu, who has sustained bleeding injury in between chest and belly at Dalakpula Chaka. He requested me for immediate medical assistance. On being asked, he disclosed that accused Babul Sahu had given a knife blow. By that time, his elder brother Prananath Sahu arrived at the spot. Prananath Sahu is the informant, my lord. And as per the PW1 statement, informant arrived at later stage.
No, let us say that informant arrived at a later stage. What about the dying declaration? Dying declaration part is consistent. That it is you who stopped the blow. So let us say that it's a case where there is no eyewitness to the occurrence. Let us accept it. But what about the dying declaration?
Oral dying declaration.
Yes, oral dying declaration.
But in a fair manner.
So two things are against you, apart from your name finds place in the dying declaration and the eyewitnesses has implicated you. You are an absconder for 9 years. How many witnesses are there as per the charge sheet?
23 charge sheet witnesses.
So how many witnesses have been examined?
7 witnesses.
All right, I am directing it to conclude it. Let us heard the Learned Counsel for the petition, Learned Counsel for the state. The Learned Counsel for the petitioner submitted that the petitioner is in judicial custody since 25/6/2019. And out of 23 charge sheet witnesses, 7 witnesses have been examined in the trial court. And though PW7 posed himself as an eyewitness to the occurrence, but the evidence of PW1 would indicate that he arrived at the scene of occurrence. He bracketed like them PW7 arrived at the scene of occurrence after the deceased sustained the injury. The Learned Counsel submitted that in view of the delayed disposal of the trial and period of detention of the petitioner in judicial custody for more than 4 years, the bail application of the petitioner may be favorably considered. Learned counsel for the state, on the other hand, placed the evidence of PW7, who is the elder brother of the deceased, and stated
Informant of
and the informant in the case, and was accompanying the deceased at the time of occurrence. He stated to be an eyewitness to the occurrence, and implicated the petitioner to have dealt knife blow on the abdomen of the deceased, and further stated about the dying declaration made by the deceased, and that when the deceased was taken to SCU Medical College Hospital, Cuttack, for treatment, the doctor declared him dead. The learned counsel for the state further submits that the occurrence is of the year 2010, and the petitioner was an absconder for almost 9 years, and therefore he should not be released on bail. Considering the submission made by the learned counsel for the respective parties, the nature of evidence adduced so far in the trial court, and the period of absconding of the petitioner, at this stage, while not inclining to release the petitioner on bail, but taking into account that the petitioner has remained in custody for more than 4 years, and 7 witnesses have been examined out of 23, the London trial court shall do well to expedite the trial and obtain a list of witnesses from the rest of the witnesses to be examined from the public prosecutor, and summon them and try to conclude the trial by end of December 2023. The petitioner is at liberty to renew the prayer for bail if the trial is not concluded within the said period. Yes, disposed of.
Please.
item number 9.
May I please, Your Lordship?
Yeah.
My Lord, last occasion, Lordship is directed to government, my Lord, to verify the medical certificate, my Lord.
Is an application for interim bail order.
Again,
What is that IN number?
I number, my Lord. 383/23.
Okay. On what ground you are seeking for interim bail?
My Lord, the present prisoner's wife in a serious ill, my Lord.
Wife.
My Lord.
So,
In this regard, I have filed, my Lord, the certificate, my Lord.
okay, the order dated 21/7/2023 indicates that the State Council has obtained instruction from IIC Chitrakonda Police Station, which indicates that the patient has obtained ticket from OPD on 12/2/23. So that was dismissed. Okay, then filed before so and so to the concern, immediately emailed. So that was you found to be
Private doctor treated my lord in the OPD ticket obtained from the government hospital.
right.
And that,
So that was torn down. So now you are to argue the matter on merit, and the report was called for from the London trial court, and it reveals that okay, charge sheet was submitted, and one accused was absconding. So then the case was splitted off, and charges were framed, and case was sent to this court for for trial. Then out of 14 charge sheet witness, no witness has been examined. That is the report.
My Lord, custody since, my Lord, 30/11/21, my Lord.
This is a commercial quantity of ganja.
Commercial quantity.
So you are a man from Odisha.
Malkancgiri, my lord.
Okay. How many criminal antecedents you have got?
No, my lord. As per instruction, my lord.
Mr.
No, sir.
31/2021, you are in custody.
My lord.
Heard the learned counsel for the petitioner and counsel for the state. The learned counsel for the petitioner submitted that the petitioner is in judicial custody since 30/11/2021. Until date, not a single witness has been examined in the trial court. On perusal of the status report furnished by the learned trial court, it indicates that out of 14 charge sheet witnesses, no witness has been examined by the prosecution. And the case is now posted to 16/8/2023 for trial. Status report date ta देई दियंतु 31/7/2023. Land counsel for the state submitted that he has received the instruction that there is no criminal antecedent against the petitioner. Considering the submission made by the land counsel for the respective parties, period of detention of the petitioner in judicial custody, and since not a single witness has been examined in the trial court, I am inclined to release the petitioner on interim bail for a period of 3 months. While an interim bail, he shall attend the trial court on each date and shall not try to tamper with the evidence, shall not indulge in any criminal activities, violation of any terms and conditions, shall entail cancellation of bail. Just add one thing in the submission, that is a local man. Okay. All right. Disposed of, 3 months bail granted.
My lord, I have find my lord power, my lord. My name has not reflected, my lord.
Yeah.
My name has not reflected, my lord.
All right. Card Mr. Swanso, Nata likhi diyantu. Yeah.
Obliged.
11, may I please, Your Lordship? Your Lordship, this is a 20B2C of NDPS Act. My Lord, I have filed an IA number 1090 of 2023 due to the petitioner's son's wedding on 25th August.
1090.
But if the case is seen in merits, my Lord, this Honorable Court has released.
No, you decide whether you want to move it on interim application or on merit.
My Lord, if my Lord permits me, I can place both. Anything my Lord will say.
No, not both. If you want to move the interim application, then he has to obtain instruction about your son's marriage. You are taking that ground in paragraph number 4 and annex the marriage card, right?
Marriage card is annexed.
So
Annex page 2 of the annexer, more na likha hai petitioner as I'm the
it's all right. What is your instruction, Mr.?
First time it has come.
Okay. Where is the house of the petitioner?
Hathras, UP.
UP. So 25 तारीख माने all right. It comes also, it will not serve any purpose.
Let me place on merits, my Lord.
Okay. So,
but my Lord will kindly show mercy on the IF, kindly merits from satisfy now. Sir, the co-accused have been released on bail. In page 19 of the brief, I have attached the bail order. I am in custody since 6/9/2020, 6/9/2020, and the co-accused have been released in 2021. Page 19, there is the order I have attached. I am totally similarly placed.
Is it your first bail application?
My Lord, earlier I had withdrawn. I had also attached that order also, which is in page 35, my Lord. I had withdrawn that, and the date of conclusion of the trial was also directed.
So,
and May Masuru Sarjiva Gatha.
Mr. Tripathi,
Yes,
as I find that this earlier bail application was disposed of by another coordinate bench, but it has come before me whether I have dealt the very first bail application.
Yes, my Lord. Page 19, my Lord's order is there. I have attached 4-page order.
19. Okay.
Page 19.
Let us see that.
Totally similarly placed.
Just a minute. No, how do you say it's similarly placed?
My Lord,
you are in that trough.
No, my Lord. There is this FIR. I can place from the FIR.
The order I have passed. I have mentioned that one truck bearing registration number so and so was detained, in which two co-accused persons, namely S.K.SAHOO and Gulser Malik. Gulser Malik is the petitioner.
Correct.
Were there, and from the said truck, contraband ganja of commercial quantity was seized. So the other persons against whom they were just going in a Varna car, and nothing was seized from that car. So their implication was based on the confessional statement of co-accused. But you are found present in that truck and you are apprehended at the spot. So how do you say that you are similarly situated like the person who were found in the car in which nothing was found?
I am the driver merely because of this honorable court's judgment also passed in this court. Mere sitting in the vehicle does not prove conscious possession, my Lord, and under section 37.
That is to be taken into account. That is to be considered action.
I humbly pray, my Lord, considering my period of custody, and I have been rejected once, and no criminal antecedents, and my son's wedding is there. That is why I was placing
son's wedding. For that, they are to obtain instruction on that.
Kindly say date ta khali.
The you take that instruction about that son's wedding, and also you file the your local sureties document.
My lord.
The learned counsel for the petitioner praised the interim application from which it reveals that the son's marriage of the petitioner is fixed to 25/8/2023, and the marriage card has been annexed to the interim application. Learned counsel for the state submits that he is yet to receive instruction on the interim application and seeks some time in that respect. It is seen that the petitioner is a man from
Uttar Pradesh, Hathras.
district Hathras in the state of Uttar Pradesh. And land counsel for the petitioner submitted that he is in judicial custody
6/9/2020.
2020.
2020 wale.
How many witnesses have been examined?
Trial.
And stop. Let the status report be called for from the Lennon trial court, and Lennon counsel for the petitioner shall furnish the names, address, and documents up to local sureties who are interested to take the petitioner on bail. Put up this matter. Let take down. The Lennon counsel for the state shall also obtain instruction whether the address furnished in the cost title is correct or not. And for such purpose, the superintendent of police Gajpati shall make necessary communication with the superintendent of police Hathras in the state of Uttar Pradesh and obtain the written report. Put up this matter in the week commencing from
25th re bahagar hochi.
No, he cannot be let out because so many things are to be done. We commencing from 4th of September 2023. You first supply by Monday these names, address, and documents of the local sureties. That is to be verified, number one, and the intimation has also be, instruction has to be taken about your correct address. You may not attend the son's marriage. You may attend the feast also. Suppose it comes out that everything is all right, your address is right, and local sureties are right. So it will come on 4th of September 2023. Yes, next.
Obliged, my lord.
Item 12.
अच्छा फ्री कॉपी ऑफ द ऑर्डर तक दे दिया हूँ
Item 13.
My petition in custody since 14 के 18 my lord, and in the meantime the principal accused and co-accused was standing in the same footage as the petitioner has already been released by other court on other honorable court my lord, and he has been arrested for um, 24 kg possession of 24 kg 750 grams of ganja, which has not been here in his possession my lord. That has been seized from the motorcycle, and that motorcycle the documents not shows the ownership of that motorcycle, that the petitioner is the owner or related to any document my lord. And in principal accused who has been released on bail, I have annexed the order, soft copy of order at annexure 5 at page 47, and the co-accused at annexure 6 at page 50 my lord. And also I have annexed the deposition copy of the independent witness. 3 independent witnesses are there my lord, at annexure 4 my lord, page 38 my lord. 3 witnesses are the independent witnesses, and all other witnesses are the police personnel or related to police. My lord?
You are carrying what you are carrying with you.
No, that affair is that the information received by the IIC, he has ascribed the affair.
That you are carrying ganja, and the
principal accused Dusasana Parida trafficking the drugs as per affair. This present petitioner along with Deepak Kumar Das, who has been released on bail, they have been as per affair standing before the house of the principal accused Dusasan Parida, and and the police has been seized 24 kgs of ganja from that motorcycle, which has not been ownership has not been proved my lord.
Ownership no प्रमाण होते कौन है ला मिस्टर त्रिपाठी कहले कौन है?
CD is not there.
Oh, CD is not there. Get the CD and criminal antecedent.
Criminal antecedent my lord, yeah, previous bail application दिया है तला.
All right, next case.
Item 14.
Item 14 my lord, just pass over. Mr. Chand is other court.
CD available, Mr. Tripathi?
Yes.
Okay, pass over. Next.
Item 15.
Yes, Mr. Joshi.
Yes, Miller. Last occasion, Lordship was pleased to direct the government to obtain instruction and to call for the CDNC.
No, it's a case of the year
2013.
2012 and
Yes.
charge sheet submitted in 2014.
Yes, Miller.
So I directed whether processes under 82 and 83 CRPC have been issued or not.
Not issued.
No, you said
Instruction
so.
has not come. Sought for.
In fact,
so let it be taken up next week because his now interim bail order is there. So interim order of protection is there. Okay. So the London Council for the state seeks some more time to obtain instruction as per order dated 4/8/2023 regarding issuance of processes under 82 and 83 CRPC. List this matter in the week commencing from 28th of August 2023. Interim order dated 1/5/2023 is extended till next date. Mr. Tripathi, I'm just coming within 1 minute.
The 14 was passed.
D'accord.
Item number 14.
May I please, madam? Here the patient petition in custody for more than 7 years, madam. In a case under section 302, 307, 326, 323, 34 IPC. And last time,
just a minute.
report was called
Custody since one, so out of 24 charge sheet witnesses, 18 witnesses have been examined. PW 18 is examined in part. Okay. Status report was called for. Okay. 20B2C of the NDPS Act charge was framed.
302, madam. 14, madam. The case on 302. BLFL 6249.
ठीक है. Case diary. No, as per order dated 23/6/2023, you made a submission that the petitioner Tila Darua is in judicial custody since 8/7/2016. But no trial has been commenced. So on your submission, I called for a trial court record, the status report. Where is the status report? Why it has not come? Huh? It's a 23/6/23 order. Huh? Call that register judicial. Call him. I'm passing it over.
Trial not completed. Not completed for 6 years, 7 years in custody. Trial not completed. Whatever, I will let the status report come.
Ask him to whether if he has received it, then produce. Otherwise, let him ask to come here. Yes.
At 2 p.m. madam?
No, I'm the moment he is just calling him. Yes, next.
Item 17.
Letter from, what is that letter? Suitable instruction from taking the course of sons after getting the order of the court text for execution of the count. Our inspector in charge, so and so. We use the letter of the CGM Ganjam at flag X. In which it is mentioned that the petitioner, S.K.SAHOO, has died on 4/4/2001 in a road accident In view of such later, no further order is required to be passed. Yes. Next case.
Item 18.
Mr. B.K. Ragada, Vijay Kumar Behra. It's a bail application.
My lord. Juvenile, my lord.
In this case, I have already given the consent. Our name may be deleted.
Whose names are to be deleted?
Vijay Kumar Ragda,
Yes.
Ellen Patel,
Yes.
S.K. Muduli,
Yeah.
M. Sahu.
So Vijay Kumar Behra is there. Oh, he's not there today. You have obtained that social investigation report.
Latest I have given, my lord. As per earlier direction, my lord.
All right, I'm passing it over, but just note it down that mention is made on behalf of Mr. Vijay Kumar Rogat to delete his name as well as the name of his associates, that is Ellen Patel, H.K. Muduli, and M. Sahu, as the brief has been transferred and new counsel has been engaged. Henceforth, the names of the Mr. Vijay Kumar Rogat and his associates shall not be mentioned in the cause list. এটা ରଖିଥାଅ ପାସ୍ ଓଭର କରିଥାଅ ଯୋଉ ନ ଆସିବେ ଆଉ ଗୋଟେ ଡେଟ୍ କୁ ରଖିବା ହେଲା ଯଦି ଆସିବେ ତାହେଲେ ଟେକ୍ ଅପ୍ କରିବା ଆଉ କଣ yes next case
Item 19.
yes
My lord, pursuant to your lordship direction, my lord, order dated 4/8/2023, my lord, I have filed an interim application number 594 of 23 that is filed today, my lord, may not be in the record, serving a copy to the other side. That in the meantime, charge has been framed. The lordship has said that if charge has been framed, I have to amend the prayer and.
In this case, my lords, I appear, lords, to the virtual modes. Am I audible to lordship?
just a minute okay the challenge was in this revision petition to the rejection of the discharge petition.
Yes, madam.
And since that order was passed on 18/10/2022,
Yes.
I asked both of you to obtain instruction whether charge has been framed or not.
Yes.
And if so, then there is necessity of amendment to the prayer portion in challenging the order of framing charge and maybe taking some ground also
Yes,
in the. So what is your instruction?
Instruction charge has been framed. That is why I
So,
filed an IA.
What is that IA?
IA 594 of 2023, my lord.
What is that?
Not in record. Today I have filed and.
Oh, today you have filed.
Lordship.
What is the number?
IA number 594 of 2023.
Have you given a copy to
Yes,
Mr.
my lord.
Das?
Yes, my lord.
Mr. Das, you have received
Madam,
the
sir.
copy.
My lords, I'll be getting instruction, my lord. I've received the copy.
Okay,
the
copy has been served perhaps in your office. So
My lords, ma'am.
take instruction. All right. The learned counsel appearing for the petitioner submitted that IA number 594 of 2020 has been 2023 has been filed today, challenging the order of for amendment of the revision petition to challenge the order of framing charge. And the copy of the same has been handed over to the learned standing counsel for the vigilance department. Let the registry place IA number 594 of 2023 on record. Stop. Mr. Sangram Das, learned standing counsel for the vigilance department, seek some time to obtain instruction on the IA. List this matter in the week commencing from 28th of August 2023. Yes.
Item number 20.
May I please, Your Lordship? Your Lordship, in this matter, Your Lordship, the application of the petitioner is under section 229 was rejected. Therefore, Your Lordship has directed the accused to be then opinion from the all India medical.
Okay, just let me go through it. Yes, Mr. Naik. Sarthak Naik is.
I'm appearing on behalf of Mr. Sarthak Naik.
Just let me go through that. 4/8/2023, the order was passed that London Counsel for the petitioner as well as London Special Public Prosecutor appearing for the CBI. कौन sound होगी? बंद करो. That pursuant to the order dated 14/7/2023, the petitioner has been admitted in AIMS Bhubaneswar for his treatment in view of such submission, so and so. So what has happened now?
My lord, he has been admitted on 22nd of August. All the tests has been already done, but now it has been completed by 9th. It has been all MRI, everything has been over. But now they are not discharging the patients because they say there is no an order from the court, so they're not going to discharge.
Yeah.
If the treatment is over, they will discharge.
It's your
But
loss.
court cannot order for his discharge if
Well, it's actually your lordship sought for an opinion because the claim of the petitioner that he
maybe the condition of the petitioner is such that it required for thorough analysis, and that is why they have.
Yes, your lordship for
so it is for your client's benefit. Why are you opposing to the same?
No, I'm not weaping. It is now he is just simply they are keeping him.
Maybe keeping it in observation. Why are you not waiting for some time? He has been admitted in the premier institution like AIMS Bhubaneswar. They have making the diagnosis and
everything has been completed, my lord. By 9th it is completed. My difficulty is your lord. I'm the only son. I'm staying in Deccan. Nobody is there to look after my father. They are in AIMS. So they are saying that if we cannot get discharged, all the reports they have to submit the report, and they are not giving the reports also.
Naik, you do one thing. You
Yes,
take instruction whether the all the investigation is over or not.
We
and
have
if so, submit that whether he is to be discharged and again to be come to that his place.
Your Lordship,
And what is his health condition as per the previous order? You obtain that instruction.
if I may, Your Lordship, we have received certain instructions. We have received a letter by the form of an email from the AIMS itself, from the doctor. If Your Lordship may allow, may I read the letter that is sent to us, Your Lordship, by the AIMS?
Why don't you share it?
Yes.
Share it so that I can see it. That what is that?
Yeah, Your Lordship, should I share it with the court master?
Yes.
Yes, Your Lordship, I will.
Report. AIMS.
Your Lordship, may kindly give me a minute here. If Your Lordship will permit me, I can read the letter out. Your Lordship may kindly give me a minute. I will.
Contact करो कौन?
Your Lordship may kindly give me a minute.
Kindly send to the helpline number, sir.
Yes, madam. Actually, I've just saved the number. It takes a minute to show on WhatsApp. Yes, Your Lordship. I have just shared, Your Lordship. I've just shared the letter on the helpline number, Your Lordship. Has Your Lordship received it?
Yes, just wait. Share it so that everybody can see it.
Yes, sir.
You see the report. Are you able to see it?
Yes, Your Lordship.
Huh?
Yes, Your Lordship.
बड़ा size करो.
My lord,
See, read. The patient is still admitted, getting evaluated. The final report shall be prepared after 10 days. This is the report dated 16th August 2023. Are you able to see this report? एक तांग गोटे कॉपी दियन. तो सब सरीगलानी बोली केमती कहउछन्ती आपण?
the test has all MRI, everything has been done.
If Your Lordship may kindly come to the second part of the email, which is the second sheet that I have shared, Your Lordship.
Okay, just a minute.
Yes. It has been mentioned that which all reports are still pending that has to be evaluated, Your Lordship.
Okay, second of all.
Things. They are saying that we have already handed over to the department, legal department, all the reports. They are not giving any report to me.
A little bit. If Your Lordship may kindly see some further assessments like Bera and others.
For the email yesterday. No, that is on 21/7/2023.
Your Lordship, the current email that we are reading has been sent to us on Wednesday, August the 16th, where it has been mentioned that some further assessments like Bera and others, including a few examinations, are pending. This is the correct screenshot, Your Lordship. The upstairs. If Your Lordship may kindly look at the second paragraph from the top.
Some further assessment like Bera and others, including a few examinations are pending. The evaluation is likely to complete and the report ready in a week or to 10 days time. Give it.
This has been sent to us on August the 16th.
State Council. After the Land Council for the Mr. Sarthak Naik. I'm mentioning the name of Mr. Sarthak Naik.
Yes, Your Lordship, I'm much obliged.
Sarthak Naik, Land and Special Public Prosecutor, produced the latest report from the AIMS Bhubaneswar, which indicates that some further assessment like BERA, B-E-R-A, all capital, and others, including a few examinations, are pending. That report is dated 14th August 2023. and the evaluation is likely to complete and the report will be ready in a week to 10 days time. In view of such report, place this matter in the week commencing from 28th August 2023.
If I may, Your Lordship, the report is dated 16th of August and not 14th of August, Your Lordship. The mail is dated 16th of August here, Your Lordship.
Just a minute.
The part of the email where it has mentioned that.
Okay, it is 16th August. All right. So it will come in the week commencing from 28th August 2023. Okay.
I'm much obliged, Your Lordship.
What is it? 14.
Report was called for. Seven years, 1 month, 10 days in custody.
So, Mr. Tripathi,
Yes, Miller.
What is the date of custody, Mr.?
That is the same, Miller. 8/7/2016. Charge copy also.
देखिए 8/7/2016
I 8/7/2016. I be certified. Pillow. Fast. आठ 8/7/16.
ଏପର୍ଯ୍ୟନ୍ତ ଚାର୍ଜ ଫ୍ରେମ୍ ହେଇନି
60
ନା ରିପୋର୍ଟ ଚାର୍ଜ ଫ୍ରେମ୍ ହେଇନି 7 ବର୍ଷ ହେଇଗଲାଣି
7 ବର୍ଷ ମାସେ 10 ଦିନ
ଆଗରୁ ରିଜେକ୍ଟ ହେଇଥିଲା
ନାଇଁ ନାଇଁ ମେଲା
Are the Land and Council for the petitioner and council for the state. The Land and Council for the petitioner submitted that the petitioner is in judicial custody since 8/7/2016 and he has been charge sheeted under section 3 କହିଦେଲେ କଣ
charge sheeted 324 326 307 302 34 IPC
and till date no charge has been framed. Land Council for the criminal antecedent कौन अच्छी की? Land Council for the state submits that the case diary doesn't reveal any criminal antecedent against the petitioner. As per the order dated 23/6/2023, status report was called for, from which it reveals as follows. पूरा लिखी देवे after going through the status report since in spite of incarceration of the petitioner for more than 7 years in judicial custody, no charge has been framed and there is no criminal antecedent, I am inclined to release the petitioner on bail allowed.
Item number 21.
Petitioner also be a CICL Miller and Miller.
Yes,
Fact.
what about your CD and
My lord, case diary has been received just now. Just now I have received the CD, but my lord, social investigation report has not been received. Notice has been served, my lord. On the
appeared.
I am appealing
all
from
of
the
that.
file of
Right,
observed.
ये आनंद तो इन्फॉर्मेंट करो वकालतनामा ये ଯୋଉଟାକୁ ଶୁଣ ଏଟା ଆଉ ଟିକେ ଆଗକୁ ନେଇ ଆସ ଯୋଉ ଇଏଟାକୁ ପ୍ଲାଟଫର୍ମଟାକୁ ଆଉ ଟିକେ ଆଗକୁ ନେଇ ଆସ ଗୋଟେ ସ୍ପେସ୍ ମିଳିଯିବ ବୁଝିପାରୁଛ ମିଷ୍ଟର ଅମ୍ଳାନ ଶକ୍ତି ପଲ୍ files wakalatnama for it informant though for the informant which is taken on record. Land counsel for the state submit that he has received the case diary today and he has not gone through the same and he is yet to receive the social investigation report. Release this matter on 25th of August 2023. Social investigation report be obtained in the meantime. Matter to be listed indicating the name of the land counsel for the informant in the cause list as well as in the top of the brief. Yes.
Item number 23. In this case, this honorable court has passed order to the opposite party because as per Annex 2, the family judge Khorda has got no territorial jurisdiction. I informed to the judge family court Khorda. Still then his proceeding. Tomorrow is the date for evidence. So my humble submission for this honorable court.
Wait. Let me go through that order. So has filed this application challenging the order dated so passed by the Learned Judge Family Court Kurda in CRP so holding that the petition filed by the opposite parties number 1 and 2 Sujata Sahu and Soumya Ranjan Sahu under section 125 CRPC claiming maintenance against the petitioner is maintainable on the point of territorial jurisdiction. Learned counsel for the petitioner drew the attention of this court to so and submitted that in this case the appropriate court would be Family Court 2, Bhubaneswar, which has been conferred with the jurisdiction to decide the matter. Since the opposite parties number 1 and 2 are residing at present in village Bhimpur under Jatni police station in the district of Khurda, issue notice to the opposite parties on question of admission that it will be disposed of at the stage of admission. Let a copy of the petition be served on the Learned Counsel for the state on behalf of the opposite party speed post requisites so. You filed the speed post requisites. Postal addressee moved others. So return to sender, undelivered notice are kept. So they are not residing there. You are to furnish the correct address. Oh, why are you not using earphone?
The proceeding is stayed until further order.
Why it will be stayed? And also file requisites, fresh requisites for issuance of notice on such fresh address. Unutilized copy be utilized for such purpose. Matter be listed immediately after the service of notice is made sufficient on opposite parties number 1 and 2. Yes, next.
Further proceeding is stayed.
Sorry, Learned Counsel. Yes, next.
Item number 28.
Copy may be given.
Yes, ସେ ଯୋଉଟା ଗୋଟେ ପାର୍ଟ ଡାକିଥିଲି ଆର ଯେ ରଗଡଙ୍କର ପାୱାର ପଡେଇଯିବ ତାପରେ ଦେଖନ୍ତୁ ନନ୍ appears for the petitioner. You have received the case diary.
My lord.
Learned counsel for the state submit that he has received the case diary and social investigation report.
My lord.
And also the social investigation report. Place this matter in the week commencing from 4th September 2023. Yes. Huh? Oh, ठीक है चलो. So rest of the matter will take up after lunch.
Pardon to mention, my lord, I have made a interim application item 272.
Call the matter.
Supplementary list, item number 21.
My lord, I will excuse item 26. I have a false report submitted. They are residing OP and the same address. I have given an affidavit because the matter is urgent. Tomorrow is the date fixed for evidence in the court, family court.
Yes.
So let the further proceeding be stayed. It is a matter is urgent.
26.
I am giving an affidavit.
Give
Same
the-
address.
All right. Next, call the matter.
Let it be considered. Further proceeding may be stayed.
Yes, sir. Yes. Which item?
Item number 21.
It's all right. You just keep it. Keep it. Yes. Yes.
May I take a mention, my lord?
Yes. Item number.
May I please, your lords? In this case, your lordship, CD, as per your lordship's direction, CD has come, your lords, and I am providing the certified copy of the social investigation report. Copy has already been supplied to my learned senior, your lords.
Yeah.
My lord, juvenile is in custody since 28/1/2023. My lord, for commission of offense under section 20B2C, 31 kg, my
21.
28/1/2023, my custody. 28/1/2023, my.
Yes.
My 31 kg of contraband along with other 3 co-accused persons.
Yes.
Now the juvenile is before your lordship for bail, your lords.
Who is the juvenile?
My lord, the present petitioner, your lords.
Prabhat Devre petition.
Prabhat.
Which item you are? Yes, it's a commercial quantity.
Juvenile, my.
So?
Juvenile is custody since 28/1/2023, your lordship. And the CD is available. Social investigation report certified copy, your lordship, I am providing just now, your lordship. It is your lordship's view that juvenile consideration is has a super proceeding effect.
What is the social investigation report?
Social investigation report, my lord friend has supplied the copy of the investigation report. My lord, he is a labor, 14 years old, and having parents. Lordship, kindly see the last page, result of the. From the inquiry, it reveals, my lord, he is suffering poverty for which he led to doing this practice, my lord.
7 months inside your lordship in rectification home, having no criminal antecedent, your lordship.
Custody, my lord, will be beneficial for him for correction in correctional manner.
7. His father, and he was studying in class 8, your lordship. He studied up to class 8. His father is ready and willing to take care of, having no criminal antecedent.
Where are those decisions where in NDPS Act commercial quantity, in spite of the bar under section 37, you are that section 12 would.
It is your lordship's decision.
Validate decision. Get ready and come. Social investigation is taken on record, and counsel for the petitioner seek some time to cite citations that even though it's a case of seizure of commercial quantity of ganja from the possession of the petitioner, but section 37 of the NDPS Act would not stand as a bar in a case of juvenile in view of the special provision enumerated under Juvenile Justice Care and Protection of Children Act 2015. Place this matter in the week commencing from
next week. I will be supplying all the with a memo, supplementary matter.
Okay. Next yes.
Published.
Weekly list, item number 1.
May I submit?
Yeah.
This is a petition under section 374 of the CRPC. Praying for a grant of permission to file appeal against the order of the SDJ. It's Annexer 1.
Yes.
Annexer 1, that is a case I have lost under NI Act 138. By default, on 20th 9 2022, when complainant was sick, I was sick, and the SDGM court given order to be present by afternoon, but I could not present, and by default, he has dismissed, SDGM dismissed my case and acquitted, page number 16, my lord. Hence, this court dismissed the complainant and acquitted the accused in this case. After that, I filed an appeal before district and session judge, and district and session judge at page number 18 mentioned that I have to approach to your Honorable High Court to get permission under 378(4) of the CRPC.
ଇଏଟା ଦେଖ CRPC ଯୋଉଟା ମୋଟାଟା 256 ଟନ୍। टू 56 आदि अच्छी हाँ okay if I'll put a question that after such an order has been passed whether you could have filed a second complaint or not, what would be your answer? One complaint petition was dismissed because on that particular date the complainant was absent and the complaint petition was dismissed and the accused has been acquitted. Whether you could have filed the second complaint or not.
No, I'm praying for that against the acquittal. I may be allowed and permitted to file my appeal before the
No, that you have filed. I'm asking you a question that suppose you could have filed, whether you could have filed a petition to restore that case, or you could have filed a second complaint or not in such a situation. Or the only alternative remedy available to you is this 378(4).
My lord.
What is your answer?
I'm playing under 374.
You have prayed. I'm asking you the question.
District court में
Our complaint.
You take note of a decision. It may be necessary. That is 2017 Criminal Law Journal 943. 2017 Criminal Law Journal 943. It's a Orissa decision. Party name is Ramakanta Sahu versus State of Orissa, wherein it is held that where the accused is acquitted on the absence of the complainant, second complaint is not maintainable. The proper remedy available to the complainant is to file an appeal under section 378 CRPC. Okay. And once this type of order is passed, then you cannot also initiate another proceeding on the self-same of act. It would be a bar under section 300 CRPC. It is double geo part. That decision also you take note of it. It reads like this, that section 300 bars a fresh trial of an accused who has been acquitted under section 256 of CRPC. So these are the decisions which you will get. Number of decisions are there. You go through this Sony's CRPC, you will get this decision. It's a fresh matter.
Yes, ma'am.
Polite leave is granted. The land counsel for the petition shall file the appeal memo within a period of 2 weeks, whereafter the matter be placed for admission. In the top of the order you mentioned that this leave petition has been filed under section 378(4) of CRPC for grant of leave to prefer an appeal against the order dated 29/2022 of the Land SDGM Bhavani Patna Kalahandi in 1CC case number 49 of 2018. In dismissing the complaint petition filed by the petitioner and acquitting the opposite party, invoking power under section 256 CRPC in a case under section 138 of the Negotiable Instrument Act. It seems that challenging the impugned order dated 29/2022 passed by the Learned SDGM Bhavani Patna, the petitioner preferred criminal appeal number 9 of 2023 in the Court of Law and Sessions Kalahandi, Bhavani Patana, but the Land Appellate Court by order dated 15/5/2023 held that the complainant in a case under Section 138 of the NI Act cannot challenge the order of acquittal before a sessions court under the proviso to Section 372 CRPC, and his only remedy is to file an appeal in the High Court with special leave under Section 378 bracket 4 of CRPC. At the Land Council for the petitioner, leave is granted. Rest part of the order is this. So you file a appeal memo, then it will be listed for admission and notice will be issued.
Okay.
Yes.
Item number 2. Item number 4.
May I please, Your Lordship? My Lord, here the very initiation of a proceeding under section 144 of CRPC is under challenge. And the challenge is on the ground that that is annexure 9 or Lords will get the order. Here, my Lord, the executive magistrate Daspala, my Lord, he is the executive officer Devata. In his case, he has filed the case, initiated the proceeding and has passed the order. Prior to that, Your Lordship may turn to page 21, Annexure 6.
No,
There, Your
but
Lordship,
when that order was passed,
that order was passed on the 60 days time has not
13/6/2000.
13/6/2023.
So 60 days has already gone.
Yeah, that's 60 days.
So that order is no more in force in view of 144(4).
Yes, yes, that is the 60 days time.
So the order under 144 CRPC, which is under challenged, was passed on 13/6/2020. Subsection 4 of section 144 states that no order under this section shall remain in force for more than 2 months from making thereof. Since 2 months have already passed, I am not inclined to interfere with, and the order has lost its force. I am not inclined to entertain this petition, which is accordingly dismissed. Yes.
Your Lordship may say
Okay, disposed of.
Item number 7.
May I please, Your Lordship?
Yes.
Well, may I please, Your Lordship? Well, before I go to the brief, Your Lordship, just have a glance. Whether this petitioner is the owner of Mesa SAHOO Coke, Your Lordship. But he's having a manufacturing unit at Ongo.
No, you are. What is your prayer in this writ petition?
My prayer, Your Lordship, is to quash the multiple affairs which has been lodged against me for the offences under section 379 of IPC.
Which FIR you want that it should be quashed?
Well, Annexure 8 series, Your Lordship.
Just a minute. Annexure 8 series.
8 series, Your Lordship. I have also given it in the tabular form, that is at page 10. All the affairs I have given.
How many affairs have been lodged against you?
There are altogether 6 against. It is not against me, Your Lordship. Well, affair has been lodged against some persons, unknown persons, and their statements were recorded when they were arrested because they were carrying in their motorcycle certain coals to the extent of 500, 700 rupees. And after their arrest, it was they have stated before the police that we are transporting this for the purpose of supplying to the petitioner.
No. This SAHOO, this petitioner in this case is one SAHOO Coke.
Mesa SAHOO Coke.
And you represent the SAHOO Coke. As
My lord, I am the.
You are the proprietor.
I am the proprietor. I am having the license, trading license under the MMDR Act, Regulation Act.
No, question is that whatever FIR you have filed, your name or this SAHOO Coke's name doesn't find place in the FIR. Not your name even. This Jaswanta Sahu's name is not there in the FIR. FIR has been lodged against either some unknown person or against some known person in some cases. It's valid. Now, you mean to say that during course of investigation, the accused stated that they are going to give these coals to you. That is how you apprehend that you may be arrayed as an accused.
My lord.
So why the FIR will be quashed?
My lord. Basing on these FIRs,
it does not make out an offence against them, against the person against whom the FIR has been registered.
My lord. What?
No, look at your prayer.
My lord.
You are challenging to quash the FIR. Once the FIR is quashed, means everything goes.
But FIR and investigation under the 21 of the MMDR Act.
I am not telling about that. The thing is that FIR has been lodged against X.
My lord.
You say that even though the FIR has been lodged against X, you are likely to be implicated in that case. So I
have been implicated.
It's all right. Let us say that instruction will come that yes, subsequent stage you have been arrayed as an accused.
My lord.
I'm hypothetically telling that state will obtain instruction, produce the case diary, and from the case diary it would reveal that you have been arrayed as an accused. All right.
My lord.
So what would be your prayer? You should pray that the proceeding against you to be quashed, not the FIR.
My lord. My lord, I have multiple prayers here, Lordship. Multiple proceeding against me may be quashed because he is not the person.
That prayer you have not made. You have made the FIR should be quashed. Why those persons will be let out?
My lord. That I will amend my prayer, your Lordship.
That I am telling you.
That first prayer.
Amend your prayer and argue the matter.
My lord.
Why the FIR against them will be quashed?
Well, I do follow.
All right. The Lieutenant Counsel for
another.
It's all right. You argue. You just get ready and Mr. By the way, in the meantime, you obtain instruction about the status of these cases. Whether this statement which has been made by the Lieutenant Counsel that during course of investigation, he has been arrayed as an accused, whether it is correct or not. Okay.
My lord, one more submission. Basing on this statement, my entire factory has been vandalized by the police official.
All right, we'll see.
Annexure 9, page 71.
Just file and IA to just amend the prayer.
That I will do.
The Lieutenant Counsel for the petitioner files an intends to file an interim application to amend the prayer. However, he submits that even though the FIR has not been registered against the petitioner, but during course of investigation on the basis of statement of the co-accused, statement of the accused persons, the petitioner has been arraigned as an accused. Let the Land and Council for the state obtain instruction about the status of the first information reports which have been annexed as Annexure 8 series. Free copy of the order be handed over to the Land and Council for the state. Matter to be listed immediately after the interim applications is filed. Okay, giving copy to the Land and Council for the state.
Well,
Yes.
well, may I pray, Your Lordship, I filed an interim application.
Sorry. Yes, next.
That will be taken up at
I am telling that if you file an IA on Monday, it will come immediately. Means next Friday.
Sorry.
Yes.
Item number 8.
Yes, Mr. Das. Prashanna Kumar Das. What is this, Mr.
Complaint
Tripa?
case against complaint the BLPA.
Is a fresh application?
Yes, sir. First time it has come.
Why it has come to me? I have dealt with it earlier or what?
Yes, Muller. Four application have been rejected.
Of this present petitioner?
Flag A to D. Okay.
The name of the petitioner is
Bhagavata Sahu. Bhagavata Kumar Sahu. Bhagat Kumar Sahu.
Bhagat Kumar Sahu. Yes, earlier he filed one anticipatory bail application, that is 16475A. Order ta achi dekhilo 164. So is 420. It's a case arises of account. Cognizant summons have been issued to the petition for their appearance. No apprehension of arrest shall be disposed of. Why he has again come? Because when he approached earlier,
yes,
a summons was issued in a complaint case. So I held that there is no apprehension of arrest. Again, why he has come?
Para 5 will confusing.
Para 5?
Yes. After registration of the 1CC, police investigated the case. But there is no FIR, nothing.
Has he given that order under 156.3?
No, Miller.
Then?
Only complaint case is filed.
Unless that that goes to that police,
yes,
under 156.3, there is no question of registration of the FIR. And he has not also filed the copy of the FIR.
Order also 156.3.
That is not
filed.
All right, Lekon. None appears for the petitioner. The petitioner earlier approached this court for anticipatory bail in ABLA PL number 16475 of 2021. And this court by order dated 25/1/2022, taking into account that the case arises out of a complaint petition in which, after taking cognizance of offences, summons have been issued to the petitioner for his appearance, and since there is no apprehension of arrest of the petitioner, this court was not inclined to entertain the anticipatory bail application. However, observe that in the event the petitioner appears before the concerned court within a period of 4 weeks and move an application for bail, the same shall be disposed of as expeditiously as possible by the courts below in accordance with law. This successive anticipatory bail application has been filed by the petitioner, and a ground has been taken that after in paragraph number 5 that after registration of the 1cc, police investigated the matter, examined the witnesses and searching the petitioner to arrest him. No order passed by the London SDGM Jajpur under section 156(3) CRPC has been annexed, nor the first information report. Only a copy of the complaint petition has been annexed to the anticipatory bail application. Therefore, there is no material before this court that the complaint petition was referred to any police station under section 156(3) CRPC for registration, and accordingly the FIR was registered and the police is investigating the case, for which there is apprehension of arrest of the petitioner in connection with that case. Therefore, I am not inclined to entertain this ABLA, successive ABLA appeal, which stands dismissed. Yes.
Item number 9.
Mr. Barik, Umakant Barik, you have received the case diary?
Yes.
All right, pass over.
Item number 10.
May I please, madam?
Yes,
Second
Mr.
round,
Chan.
This is the second round, Johnny.
What is this IA, Mr. Chan?
I am permitted to withdraw, madam.
IA number 91 of 2023. The Land Council for the petitioner seeks permission to withdraw the interim application. Accordingly, IA is disposed of as withdrawn.
Yes, doctor's report.
Doctor's
report. Called for.
Last order টা টিকে দেখলে কোন হয়েছে 2/1/2023 তারপরে আর অর্ডার হয়নি
না
সে 302 case
302 my take
and
one aspect
the status report is dated 9/1/23, Mr. Chan, in which it is mentioned that out of 16 charge sheet witnesses, 6 witnesses have been examined. So in the meantime, almost 7 more months have passed.
Call for
So, Lekhandu, period the status report dated of the Lanen trial court dated 9/1/23, from which it appears that after framing of the charges under section 323, 324, 307, 302 of the Indian Penal Code, out of 16 charge sheet witnesses, 6 witnesses have been examined. The London Council for the petitioner is not in a position to say about the status of the case, since in the meantime 7 months have already passed. Let a fresh status report be called for from the London trial court, and for such purpose the file be placed before the London Register Judicial Usual Order, matter to be listed in the week commencing from 28th August 2023. Yes. You have got those deposition copies with you. All right. While sending the status report, the London trial court shall send the Xerox copies of deposition of all the witnesses examined so far, and the registry shall supply the copies of the same to the London Council for the state as well as Land Council for the petitioner.
Item 11.
Mr. Amulya Ratna Panda. Pass over. CD available?
CD available.
Yes.
Das has disposed of the first FIR on 8/7/2019.
What is that number? Can you tell me?
5806 of 2018.
Of one of the co-accused.
Yes.
The London Mr. Ashuvan Das Land Council senior advocate submits that first bail application in the case in BLAPL number 5806 of 2018 in respect of a co-accused has been disposed of by Honorable Justice D. Das in view of the sworn sausage contra RCG. Place this matter before the appropriate bench with the approval of the Honorable Chief Justice. Yes.
Item 15.
My pleasure, Lordship. Well, case 302 is there.
No, you are apprehending that your case will not reach, so it has reached. So
I am greatly obliged.
yes.
Because of that.
So is it your first application?
Yes, first application.
But what about these other applications?
Other applications, your lordships, I don't know. I am moving this petition.
No, the
The other cases, your lordship granted bail.
No, it's all right. The now the that order has come, standing order, that whosoever has disposed of the first bail application,
My lord.
it has to go to
Yeah,
him.
your lordship dispose of the
Then it would come.
first,
That is
because
right.
my lord, it had gone to my lord Justice Nursing.
Ah.
Then my lord Justice Satpathy.
No, not only in respect of the petitioner, any of the co-accused.
And your lordship, first in these cases, your lordship granted bail. I moved the case for the first time.
It's all right.
That order copy is there before your lordships also.
Okay, so you have received the case diary, Mr.
Yes, my lord.
Okay.
Then
Argue the matter.
my lordship, kindly look at that. My lord, just the backdrop of the case I am submitting to your
No,
lordship.
have I dealt this matter and granted bail to any accused?
Yes.
Where is the bail order?
Bail order, my lord. Your lordship, kindly see. The order copies I have given.
No, what is that bail application number?
I'm one by one I am giving, my lord. My lord, that is 16. Your lordship, kindly see. The order that is BLA PL number 4593 of 2020.
Okay, I'm just going through it. It is available with me.
Right.
Mr. Tripathi?
Yes, my lord.
So, some of the accused persons have been, co-accused persons have been granted bail, as it appears from the order dated 17/8/2020, passed in BLAPL number 4593 of 2020.
May I point out another thing, my lord?
Yeah.
Page 19, lordship, kindly see. Page 19 of this petition. This order, your lordship, just going through it. Page 19.
Yes, sir.
My lord, so far, your lordship did not grant bail at the first instance. Your lordship will find in the middle portion, namely Ashok Bhatta. My lord, he has been also granted bail. And my lord, your lordship will find
No, I just want him to examine the claim of parity, whether the petitioner is similarly situated or not. That would cut-short the matter. Mr. Tripathi?
Yes, my lord.
So, what is your submission, whether the petitioner case is similarly situated like the other co-accused persons?
Copies of the bail order.
Why are you not giving them?
No, that is annexed. That is annexed.
Yes.
That is annexed. Kindly see. I have given also on the last.
Please show him. He is not having those copies.
Yes, page 16. Page 16. I would have bail order village.
The first one is no. You come to page number 19. Then which was he is placing. That is also passed in respect of 7 petitioners.
Yes, my lord.
So that is names are there. Then they have filed another order that is 5914 of 2020. So
that is after your lordship's order that was passed. Again, your lordship passed the other order.
So you are just to verify, we can take up this matter next week. You have not verified.
Yes, sir.
Just this claim of parity, you examine and tell me that there are eyewitnesses to the occurrence.
Yes, yes. Eyewitness, my lord, in this case, he was not in the spot. He is, as your lordships analyzed and from the affair, your lordship indicated this. He was never named in the affair, and your lordship more parity. My lord, lordship will find here also page in Ashok Bhatta case. My lord, I am passing on this order also.
No, Mr.
Yes,
Tripathi, you come to page number 20.
20, yes.
Okay, come to the middle portion. I have, after hearing all of you, the submission is that it appears that specific overt act has been attributed against co-accused person so and so so and so. ଏଇ ଯୋଉ 1 2 କେତେ ଜଣଙ୍କ ନାଁ ସିଏ କହୁଛନ୍ତି ତା ନାଁ ହଉଛି ସରୋଜ କୁମାର ସେଠୀ ୟା ନାଁ ଆ ଭିତରେ ନାହିଁ. Then the State Council also verified and fairly admitted that the specific overt act relating to the assault on the 2 deceased has been attributed against 6 accused persons. Who are those 6? ତା ପୂର୍ବ ପାରାରେ ଯୋଉଟା ମୁଁ ଦେଖଉଥିଲି ଆପଣଙ୍କୁ, ଅଶୋକ ଭଟ୍ଟ, ବ୍ରହ୍ମଚାରୀ ମାଝୀ, ଗିରିଧାରୀ ବେହେରା, କେଳୁ ବେହେରା, ସୁର ମାଝୀ and କେଦାର ମାଝୀ. So 1 2 3 4 5 6 ଏଇ 6 ଜଣଙ୍କ ନାଁରେ it's a case of double murder, but specific overt act ଏଇ ମାନଙ୍କ ନାଁରେ ହେଇଛି.
But other eyewitness say about 17 persons.
ସେମାନଙ୍କ ନାଁ ଏମାନଙ୍କ ନାଁ ବି କୁହାଯାଇଛି, but there is general allegation, omnibus allegation. ତେଣୁ specific overt act ଯୋଉମାନଙ୍କ ନାଁରେ ଅଛି ସେମାନଙ୍କୁ ମୁଁ specify କରିଦେଇଛି. ଯୋଉମାନଙ୍କ ନାଁରେ omnibus allegation ଅଛି ତାଙ୍କୁ bail ଦିଆହେଇଛି. ତେଣୁ if you come to the concluding part also of that order, page 21.
Yes.
Please see, verified. Considering the submission of the learned counsel for the respective parties, absence of the names of the petitioners in the FIR, though it was lodged by one of the eyewitnesses. So, semanakara na nathila. Whether the petitioner name is there in the FIR or not, that is to be seen. One asking. Then, absence of any specific overt act against the petitioner. Number 2, relating to the assault on the deceased. Further relating, ତେଣୁ ଆପଣ ଯଦି claim of parity ଦେଖିବେ ତାହେଲେ first of all ଦେଖିବେ ଯେ specific overt act ଯୋଉ 6 ଜଣଙ୍କ ନାଁରେ ଅଛି ସେମାନଙ୍କ ଭିତରେ ୟା ନାଁ ନାହିଁ. If he is the single petitioner, I do not know whether it is. ଆଚ୍ଛା ନାଇଁ, ସରୋଜ କୁମାର ସେଠୀ, this petition has been filed, okay, single. So ସରୋଜ କୁମାର ସେଠୀ ଆଉ ସରୋଜର ନାଁ ତା ଭିତରେ ନାହିଁ. Next comes whether the FIR mentions his name or not.
Not
so
there.
यार FIR नारे सरोजो नहीं. देखना दी FIR page number 12 रे.
May kindly see another BLA PL number 116.
No, it's all right. Come to page number 12.
Yes.
So you see that the names which have been mentioned in the FIR, 7 names are there.
Yes.
In that, the name of this present petitioner, Saroj Kumar Sethi alias Saroju, is not there.
Not there.
So, in both the grounds which has been mentioned for grant of bail, that is applicable to the petitioner. Since when you are in custody?
My lord, he is in custody from 3/1/2023.
Are the learned counsel for the
criminal antecedents.
Oh, then you file the.
No, that affidavit, lordship, kindly see.
Where is that?
Affidavit is there. We have filed that affidavit. That is not there against. Lordship will find I have filed in the court record is there. That is, I filed it on 8/5/2023, pursuant to the order of the Honorable.
You have mentioned that you have been released on bail.
Yes. In those cases.
By the way, what are the offences?
Yes, ma'am.
In those 5 cases.
Lordship, can have a look at that affidavit.
No, I'm holding that affidavit.
Yes, ma'am.
But the offences are not mentioned. That's why.
First one is 170, 171, 406.
No, tell me the major offence, not
420.
That's a magistrate tribal offence.
468.
Yes. Second one.
Second one 302.
302 is there.
Yes.
What is that number?
37.
No, it is case.
9.
309. 3029.
No, 8. 37.
Okay, we will leave that. Next
is 66 Judah. 420. 468 সেটা
Okay.
তারপর other are same.
There is no other offense like 302 in
No. Only in this case.
Are the learned counsel, senior advocate, Mr. Mahanti, submitted that the petitioner is in judicial custody since 3/1/2023. And he has been charge sheeted under section. Please tell the offenses. Charge sheet offenses.
147,
Take down.
148, 341, 323, 324, 325, 326, 307, 302, 395, 506, 149.
No other offense. Arms Act of the Indian Penal Code. He further submits that some of the co-accused persons who are similarly situated have been released on bail by this court in BLAPL number 4593 of 2020 by the order dated 17/8/2020, BLAPL number 4802 of 2020 by the order dated 17/8/2020, BLAPL number 9035 of 2020 by the order dated 22/4/2021, and specific overtact has been attributed against co-accused persons Ashok Bhatta, Brahmachari Majhi, Giridhari Behera.
Ashok Bhatta release.
I'm coming to that. Kelu Behera, Sura Majhi, and Kedar Majhi. Check once again. Ashok Bhatta, Brahmachari Majhi, Giridhari Behera, Kelu Behera, Sura Majhi, and Kedar Majhi. And the name of the petitioner doesn't find place in the first information report. And nature of accusation against the petitioner and the co-accused persons who have been enlarged on bail are omnibus in nature, and therefore the bail application may be favorably considered. Learned counsel for the state, after going through the bail order copies filed by the learned counsel for the petitioner and the case record, doesn't dispute that the name of the petitioner doesn't find place in the FIR and that no specific overtact has been attributed against the petitioner. Considering the submission made by the learned counsel for the respective parties, nature of accusation against the petitioner, absence of any specific overtact against the petitioner relating to the assault on the deceased persons, Durga Pradhan and Biranchi Pradhan, release of the co-accused persons on bail, and further taking into account the period of detention of the petitioners in judicial custody, I am inclined to release the petitioner on bail allowed.
My lord, commitment
It is to be before the court in session. So wherever it is pending, you can.
Commitment.
Are you having the?
No, only information.
That's okay. So you just file it. Any court will accept it.
My lord, obvious.
Yes.
Item number 16.
Please, Your Lordship. My lord, petitioner is inside the custody since 20th September 2022. My lord, in the meantime, charge sheet has been filed showing the petitioner as absconder, and trial has already been concluded, convicting the co-accused persons under section 302 and 34 IPC. My lord, during the course of trial and in the appeal also, the co-accused persons are on bail. Now the petitioner is inside the custody. So your lordship may kindly consider his case.
No. It's a case of the year 2014.
14, my lord.
So you were apprehended or arrested, or I do not know whether you surrendered or whatever it may
No,
be.
arrested.
All right. So 29/2022 is the date of arrest. Now you say that some of the co-accused persons in the meantime faced trial and they have also been convicted.
My lord.
So why don't you produce the certified copy of deposition of the witnesses and let us see what they have stated against you?
My lord, I will supply, my lord. I have already supplied the release order of the co-accused persons.
That's a different matter, but he has to verify that what statements the witnesses have given.
Kindly see annexure 2, my lord. I have annexed DW1 deposition.
Yes.
DW1, my lord. Annexure 2. Pressing on.
Why are you showing DW1? Oh, you must show what the PWs are stated. DW1 is your witness, the witness of the defense. Okay.
My lord.
Find out the deposition copies of the prosecution witnesses and let us see what the witnesses have stated. The learned counsel for the petitioner submitted that it's a case of the year 2014. Co-accused persons who faced trial have been convicted and they have preferred appeal before this court and they have been released on bail by this court. The petitioner was arrested on 29/2022. He seeks some time to produce the deposition copy of the witnesses examined in the trial court during the trial of the co-accused persons, giving copies to the learned counsel for the state. List this matter. Kebe debe kon?
I don't know. 3 weeks time.
Because for obtaining the certified copy, you have to apply there. Now the original case record is not coming to this court. It is there in the trial court in the record room. Only the Xerox copy is coming here, and we are so apply the certified copy there and get it. All right. Release this matter in the week commencing from 28th of August 2023. Yes.
340. My lord, it has been pending for last almost 7 months. It came from the Supreme Court on remand. It came from Supreme Court on remand, my lord. It had gone to my lord Justice Narasimha.
So you do this 32 item to supplementary in
I pray, my lord, item 272, I pray for interim bail, lordship, the morning hour, lordship.
My lord, item number 315, my lord. ତାতে ଗୋଟେ ଆଇଏ ଫାଇଲ ହେଇଛି, ସେଟା ଆପ୍ ନୋଟିସ୍ ମ୍ୟାଟର ଆସୁଛି, ପଢୁନି 5 ସପ୍ତାହ ହେଲା। ସେଥିରେ ସାର୍ ବେଲ୍ ଏନବିଡବ୍ଲ୍ୟୁ ଟା ଇସ୍ୟୁ ଷ୍ଟେ ହେଇଥିଲା। ସାର୍ ଷ୍ଟେଟା ଭେକେଟ୍ କରିବା ପାଇଁ ବର୍ତ୍ତମାନ ସୁପ୍ରିମକୋର୍ଟ ଗାଇଡଲାଇନ ଅନୁସାରେ ଭେକେଟ୍ କରିବା ପାଇଁ ତଳ କୋର୍ଟ ନୋଟିସ୍
all right, it will be taken up next week. There is a division.
ଅର୍ଡର୍ସରେ ସାର୍ ଆସିଲେ ସାର୍ ହେଇଯିବ ନେକ୍ସଟ ୱିକ୍ ଏନି ଡେ ସାର୍ ଅର୍ଡର୍ସରେ ଆସିଲେ
Okay, you mention next week.
ମାଇନର